Hi law students, Professor Orenberg here, and today I want to talk to you briefly about how to succeed in law school. A lot of you are just starting this week, and I had the joy of welcoming about 140 new students into the profession today. Got me thinking about the essential tips I think every law student can benefit from. This is an advocacy profession. Your job is to represent a client and get them to a result. And we're going to evaluate you on your ability to do that. So, how do you succeed in your first year of law school is by showing your faculty that you're capable of performing this evaluative exercise. And I think we can get there in just a few short steps. You're going to be presented with some new situation, some new set of facts, sometimes called a hypothetical. And you have to take these facts and do legal analysis. What does that mean? How do you do that? I will give you just a few short steps to get there effectively. One, each set of facts will draw one or more legal issues to bear. A legal issue is a question, the resolution of which will resolve the legal dispute in a case. So for example, I teach contracts, and there's a rule that minors, also known as infants, only incur voidable obligations except for necessaries. So if the facts say Sally was 17 where she rented a room from Bill, well, she's not 18 yet, she's an infant. That might be the issue in this case, and we might have to resolve whether that rental was a necessary. Not to get too much into the substance of my course, but again, the idea is you'll be given a set of facts. From those facts, you find the issue. So that's number one. What is the issue or the issues in this case, in these facts? And again, issues, those are the questions, the resolution of which will resolve the legal dispute. Once you've located the issue or issues, those issues have rules associated with them. Those are the rules of law you'll be learning in all your doctrinal classes. You can find those rules in all sorts of fashions. You can find them from cases, you can find them in statutes, you can find them collected in restatements of law and treatises. But you'll need to connect the rules to the issues that they relate to. So we just went over one. If the issue is that a person under the age of 17 may or may not be responsible or liable for a contract, well, we need to know the rule about infants in order to analyze the facts here. And the rule in this case is that infants are not liable for contractual obligations except for necessaries. And so we have to look at whether or not that apartment was a necessary. And that's the argument section. So number one, read the facts and spot the issues or issues. Two is connect the issue to the rule that it's related to. Three is now we do our analysis. Every case has a plaintiff and a defendant. Sometimes there are multiple parties, but in first year, let's keep it simple. And even if there's not a live dispute, you can imagine one. Somebody wants to enforce the contract. Someone wants to argue there was no contract. Someone says there was a tort. Someone says there was no tort, etc., etc. There's two sides. Otherwise, it's not an argument. It's a fact. So what do? Well, take both sides. Now that you know the issue and you've remembered the rule, apply that rule to the facts presented, first through the perspective of the plaintiff. What are the claims the plaintiff could raise to win this case? I'm the plaintiff. You didn't pay me rent. I'm Bill in this hypothetical. I want the court to make you pay me rent. So I'm going to argue my cause of action is you breached your contract. You breached your promise to me. You were supposed to keep your promise to pay me rent. You didn't do it. So we'll go through an analysis there, right? There was a contract, there was offer, acceptance, consideration, what have you. You'll learn all the issues related to that in my class and in your other classes. The key thing to remember is there's a plaintiff. They're the ones going to file the claim. Start there. What's the claim? What's the legal claim? What's the basis for that claim? On the other hand, there's a defendant. There's this minor who doesn't want to pay the rent. So she will respond by defending, by saying, I don't have to pay the rent because I didn't incur an obligation, or at least one that I could void because I'm under the law of infancy and the lack of capacity. I only incur voidable obligations. And then there might be a rebuttal of some sort, right? Maybe in this case, the landlord says, yes, that's true, but here this was a necessary, it's an exception, right? So we can actually draw out all of the facts that are relevant and all of the rules that are pertinent to resolving the issue or issues by taking both sides. Plaintiff will argue, defendant will argue. So what do we have so far? We have an issue which we discovered by reviewing the facts and remembering what comes up as a matter of law. We have rules which come from our cases, which come from our restatements, our treatises, and our statutes. We have analysis on both sides. We have the argument or the application. The plaintiff will argue X, Y, and Z. The defendant will argue X, Y, and Z. That's going to flesh out the arguments. We're going to apply the rules to the facts through the perspective of plaintiff and defendant in our adversarial system. The only thing left for you to do is determine which of those two arguments is stronger. Play the role of the judge. Play the role of the judge and determine whether or not the plaintiff or the defendant should win. That's your conclusion. And by the way, that's the IRAC paradigm of writing. Check out my other videos on how to write in an IRAC format. It's a useful enterprise to write in this way because it gets you thinking in this way. But that's it, folks. That's the secret to law school. That's the whole thing. Can you read a set of facts, a story about a situation that happened between two people, determine what legal issues are raised from this set of facts? What are the disputes that may happen, or what are the disputes that are happening? This person wants money. This person wants rent money from the apartment, right, etc. Right? What's actually happening, and how are those issues connected to legal rules? The legal rules, I think that's the easy part. We have so many references. What are the rules? It's easy to find black letter law. The challenge for you is to be the advocate. Apply that black letter law to the arguments the plaintiff would make and the arguments the defendant would make. By doing it this way, you actually surface all of the best arguments, not just selective ones. It's a great way to do your analysis. Plaintiff will argue, defendant will argue, maybe even plaintiff will rebut or defendant will rebut. At the end of that analysis, you have to weigh the scales. You, as the law student, need to be the judge. We're looking for your evaluative capacity. Are you able to determine which legal argument is stronger? And that's the C in IRAC. Issue, rule, application, conclusion. It's not just a writing paradigm. It's a way of thinking about things. And it's a way you can think about things in law school to help you succeed. I hope this has been helpful, and I'll catch you in the next video.